just make a mention.
Yes.
Please, Your Lordship.
From the daily list.
By my Your Lordship's indulgence, to make a mention, my lords, for listing of a matter tomorrow. It's a fresh matter, my lords. It's a writ appeal against an order passed by the learned single judge in an electricity matter.
Huh?
Electricity, my lords, under the Electricity Act. What has happened is, my lords, there is a provision for appeal under the Electricity Act. The MACRC, my lords, that the state regulatory authority has basically passed an order in exercise of its statutory functions, fixing the tariff. Now, the state, my lords, the MECL has come in challenge before this honorable court in exercise of powers under 226, whereas there is a provision for appeal under section 111 of the Electricity Act, my lords. My lords, we are the consumers. We are aggrieved by an interim order that has been passed by the learned single judge, my lords. As such, there is an urgency in the appeal. If Your Lordships kindly have the matter tomorrow, my lords.
We didn't take it on chance on 18th.
My lords. Obliged.
It is numbered listed tomorrow. It is numbered listed tomorrow. Else on 18th.
My lords. I'm grateful. Obliged.
From the daily list, item number 1.
May it please, Your Lordship. My Lord, I am Sujit Ghosh, appearing for the petitioner. So this is the second round of litigation for the petitioner. What is under challenge is a circular issued by the Central Board of Excise and Customs and a consequent adjudication order that has been passed basis that. My Lord, before I take my Lord through the controversy, let me set up the facts. Now, the petitioner was awarded a concession agreement by NHI in 2010. That was for construction of a highway and maintenance and operation thereof for 20 years. That project, the construction work was completed in 2014. And what has also happened is 2017 is when GST came into being. At the advent of GST, the GST Council took a view that toll is exempt from GST. Let us also exempt annuity payments under GST. Now, the distinction between the two, my lord would have seen when somebody goes to the toll, people pay the toll fee to the collector that is there. That is one model. There's another model where people don't pay. The payments are made to the construction agency, the concessionaire, by NHI themselves. That's called the annuity model. Annuity model spreads over 20 years, etc. That's what the life of the project is. So, in 2017, at the advent of GST, they took a decision that annuity payments made to this concessionaire should be exempt from GST. On the back of it, there was an exemption notification that came to be issued on 13th of October 2017. We were availing that exemption, life was all fine. Suddenly, after 4 years, and that's very relevant, after 4 years, the GST Council took a volte-face. They came to the conclusion that no, this exemption was not available to them. Henceforth, this exemption should not be granted. Let a clarification come to be issued. A clarification on the back of that came to be issued in 2021 June. Now, that date is irrelevant below. As soon as the clarification came, the clarification was challenged before the Karnataka High Court. Then a single judge quashed the circular on the ground that it was without jurisdiction. The reason for that I'll come to later.
It's coming up for admission.
Yes, right. I'm praying for some interim relief and therefore I'll want to take my lot through that. So the learned single judge quashed the circular. In the meantime, a show cause notice came to be issued by the current respondent number 4 in the state of Meghalaya.
Where is your interim relief?
Yes, my lord. Lord, that is at no.
Interim petition is not there.
Yes, my lord, there is that page 104.
Where is an application?
There is no application.
No,
There is no separate
application.
application.
There's no application.
It is part of the petition, my lord.
No, it's not like a central administrative tribunal where you can have the interim prayer
I
in the
understand, my lord.
application.
I understand.
They will take notice. Yes.
Could my lord list it for interim hearing anytime? I'll file the application therefore.
My lord, in the meantime, my lord, I'm appearing for the state.
Appearing for?
Appearing for the state, my lord. State government. Here, my lord, under the Act, my
But
lord.
anyway, we are only admitting the matter.
Yes, my lord, what I want
You
to
take
say, my lord,
notice.
there is already a provision for appeal under the Act,
Ah.
section 107. And my lord,
My learned friend
section
wants to
107,
take that recourse.
Where is it? 1 minute. He says that where is the provision?
under the GST Act, my lord, Central Goods and Service Tax, section 107, my lord.
But here the challenge is to a circular. Appellate authority cannot strike down the circular.
107.
1 minute, sir.
Yes.
100?
Section 107, my lord.
107.
And subsection 6, my lord. Section 107, subsection 6, my lord.
1 minute, 1 minute. Sorry. What is the order to challenge now? What is the order to challenge? What is the prayer and petition, sir?
Order under challenges, my lord, Annexure 1.
Page number 107.
107. Annexure 1, page number 107, my lord.
107.
Yes.
Yes.
And moreover, my lord, section 107, clause 6, my lord, it says no appeal shall be filed under subsection 1 unless the appellant has paid in full.
That is right.
Yes. And
Lord,
the sum equal to 10%.
Let me make my submission to that.
So what is that now?
10% it says, my lord.
Yes. What is the amount determined or demanded?
It's 102 crores. 102 crores.
112 crores, my lord.
112 crores.
112 crores.
112
That means you'll have to pay 11.2 crores.
That's right, but I'll need to make my submission in respect of the alternate remedy that learned friend says. Challenge is to a circular. Circular cannot be assailed before the appellate authority. As long as the circular is there, the impugned order will sustain. Our difficulty is the circular. That circular has been quashed, and that is what we are challenging. That is one.
So we will grant an interim order saying that you pay 11.2 crores on condition to deposit.
Hear me in that case, because similar matters have come up before other high courts, and whatever has, I'll place those before that. The Guwahati High Court has stayed the show cause notices. Andhra Pradesh High Court has stayed those notices. I'll just point out that, my lord, will find that. My lord, comes to page number 538. Let me place the Guwahati High Court decision. It's a detailed judgment.
I think you came up, if I remember correct.
No, the Karnataka High Court is the lead in this. My lord, has that page 538, annex to 38? May I read out, my lord?
Demand so and so, so and so.
So, etc. The
But anyhow, the order passed with the other court or the interim order will not bind us.
no difficulty.
Even the same High Court,
Right.
the interim order is there, it will not bind the other
I am not pressing. I'm only saying that there is a prima facie case. My lord,
you
may permit
deposit,
me- may not put me to condition. Let me make my case out. Therefore, let me hear me on that. Because this is a case where the circular has already been quashed by a particular High Court. Insofar as the circular is concerned, we are challenging that. B, the most important point that has to be kept in mind is that circular has been issued in the teeth of section 11.3. Kindly see section 11.3, my learned friend has brought before my lord provision.
anyhow, let them take notice, they will decide. So we may impose some cost also to be cost not short, the interim order for you to deposit some amount.
My lord may hear me on the prima facie. I'll make the case because this is a case where the circular is in the teeth of the power under section 11.3. 11.3 says,
Such a balance between both the parties and the interest of justice, the court can say that you deposit some.
no, certainly. But at the same time, my lord will also consider the balance of convenience also. Insofar as I am concerned, this is a
You are entitled
project.
to, you according to you, the circular cannot be questioned before the authorities can.
That's right.
1 point. Therefore, you have got a right of appeal because it's an order under challenge.
Right.
So everyone will challenge the order indirectly by challenging the circular or
appreciate
the notification, whatever it is.
But what happens
That cannot be given,
what happens when the order itself, for a minute, what happens when the order is without jurisdiction? This is the section 74 that has been
those things can be considered.
Will not hear me on that particular point. I'll make good my case. Section 74 is for suppression. And the show cause notice comes to be issued
Can you take
in
notice?
2020.
Take notice.
Well, we'll keep it for some day for hearing on my interim relief, my lord.
Respond number 6, the notice has to go, GST Council.
Returnable by when? Today we are on 15. weeks?
Sorry, my lord.
4 weeks?
4 weeks should be fine, my lord. May keep it.
Yes. 19th August,
My lord, 19th August may be difficult. It's a
20th
Friday.
August.
No, any day before that, my lord. Any day before that.
So you want to get an adverse order from this bench and then.
My lord, for us, my lords are the
See, I have gone through the paper.
Right.
I feel, I thought there should be I have not noticed this appellate provision,
No,
but I thought there should be an interim order
Absolutely.
passed by this
In
court,
fact,
depositing some
Lord,
amount.
I am relying upon a Madras High Court decision, not because my lord comes from Madras. There, what had happened, the division bench had held that if an order is on the basis of a circular, which is binding on the lower authority, Justice Shivagaram's order, then no useful purpose would be served in going before the lower authority.
Correct, because the order, the circular will bind them. Because they cannot.
Correct. So therefore, 107 appellate proceeding does not apply. And at the same time, what is equally relevant, my lord, is that that particular circular has been quashed. And yes, my lord. My lord, may keep it on 10th of August, my lord. My lord, may keep it on 10th. 10th of August, subject to convenience.
That is Saturday, no?
It's okay.
So the calendar.
10th is
Saturday.
10th is Saturday.
Then
What do you say?
14.
14th, my lord, subject to convenience. 14th?
Put it.
I am obliged. In the meantime, I'll file my application for interim stay, my lord. I am obliged.
My lord, respond number 6, the notice has to come out.
Yes. Notice, so and so takes notice for the
In fact, my lord,
notice,
there is a-
private notice, court notice and private notice to the respondent 6.
in fact, my lord, the observations of this honorable court in the earlier round and that of Supreme Court is very pertinent here. This court placed faith in the adjudicating authority that they will follow the judgment of Karnataka, and so did the Supreme Court. They did not. And that's what it is. I am obliged.
Put it on the list.
Obliged.
Item number 2. Can you just
May I please to Lordship?
Yes, madam.
Lordship, this is an application for continuation of delay of 39 days in filing the criminal appeal.
What is this? Delay.
Yes, Your
How
Lordship.
many days?
39 days, Your Lordship.
39 days. Here
Again,
they say 43 days. Or 39 days.
Lordship is against,
Pokso or
no, Your Lordship, 302 of IPC, Your Lordship.
302? What is the offence? What is the offence?
302, Your Lordship. 302 IPC.
302. Yes. Delay condoned.
May it please your Lordship. Lordship, this criminal appeal has been filed under the new code, Your Lordship.
Under the?
Under the new code, under the BNSS, Your Lordship. Lordship,
Should be on the old one.
this was the trial. under
When
the
was
IPC,
incident?
Lordship.
Occurrence.
2005, Your Lordship.
205.
Lordship, by virtue of section 531 of the new code,
Saving class.
Lordship, yes. If Lordship kindly have a look at section 531.
Your Lordship, if permission may be granted to amend our cause title. To amend our cause title, Your Lordship.
I mean the cost title.
In the criminal appeal,
What is it you want to amend? Cost title.
Lordship,
What is the amendment in the cost title required, madam?
regarding the new act, Your Lordship.
Not the cost title.
you appeal.
Show me the provision.
Lordship, kindly have 531 of the new code.
5.
531, Your Lordship, of the new code. Your Lordship, at page 156.
That's what I asked you. Repeal class, repeal and savings.
Lordship, yes. May I read it, Your Lordship?
The old act, you have to file it based on the old act.
Lordship, if Lordship kindly see 531, then 2A. If immediately before the date on which this Sanhita comes into force, there is any appeal, application, trial. Lordship kindly see the trial. Inquiry or investigation pending, then such appeal, application, trial, inquiry or investigation shall be disposed of, continued, held or made as the case may be in accordance with the provision of the Code of Criminal Procedure 1973 as enforced immediately before such commencement, hereinafter refer as the said code, as if this Sanhita had not come into force.
Correct.
So, Your Lordship, this
They have to file based on the old act,
Lordship, yes.
old code.
Yes, Your Lordship. This is my contention, Your Lordship, because this appeal, the present appeal has
But
been
any of
filed
this
under-
only a technical objection. We can say consider based on the saving clause. Based on the saving clause, we can say that you address argument based on 1973 code. We can say that let them address.
It should be under 1973 code, Your Lordship. No,
Yes, correct.
Lordship, yes.
We agree with you.
Lordship, yes.
Under which code they have filed? New one.
Page 1 of section 4152 of the Bharatiya Nagarik Suraksha Sanhita 23.
You have to amend it.
Yes, Your Lordship.
Anyway, we'll condone the delay.
Oh, Lordship, let them correct first, then Lordship.
Then it will take time. Anyway, going to
Lordship,
delay is going to
then
take
ask
more.
Lordship, please.
Delay is going to be common.
Lordship, certainly, Your Lordship. I'm not objecting to the delay, Your Lordship.
Condone. And, in view of section 531, so and so, Act 2 2023, the present appeal will have to be filed under the old code. See, we cannot return, if I condone the delay, we'll have to retain the papers. We cannot return the papers to you for the purpose of correction. So we'll adjourn the matter. You get it. Don't condone.
Or can I, Lordship, they can withdraw and file it afresh.
No, Your Lordship.
They can withdraw and file it afresh, Your Lordship.
Oh, why don't you withdraw and file a fresh
Your
one?
Lordship.
No, Your Lordship. We'll just amend, Your Lordship.
You have to, after amending, you will have to file a fresh set.
Your Lordship, I mentioned only in one page, Your Lordship. So
Okay.
only in page 1 of the criminal appeal, Your Lordship, that section.
Page 1. Hey, let them do it.
Lordship.
Post the matter after on 29th to enable the petitioner to amend the provisions of the Act and represent the same, as it has been contended by the respondent public prosecutor that in the light of section 531 of 2023 Act, appeal needs to be filed as per the old code, not in terms of the new code.
Lordship, obliged.
My Lord, if I may apologize for. My Lord, this issue, my Lord, whether the old code will apply to fresh applications of fresh appeal, my Lord, this is pending before several high courts, my Lord. It appears.
Madras High Court is also ordered. Madras High Court, I think, ordered with regard to the change of name subject to correction.
My Lord.
But in the light of assuming that new code is going to be is not going to be there, they are intended to file an appeal in terms of the 1973 code.
No, my Lord, what happened? What is pending on that day, my Lord, when the new act came into force? Those are to be decided as this is what the Punjab and Haryana High Court just yesterday.
You have to take
I was
into
going
account the date of offence.
My Lord. No, my Lord, date of offence is not material, my Lord.
Then
But it's 531, as your lordships have just to. Well, it's the same issue came up in another matter the other day.
before this bench.
No, before my lord's honorable, my lord honorable Justice Dindor. My humble submission would be, my lords, that would be only in respect of the trial, my lords, not in respect of, my lords, any fresh application that would have to be presented on a subsequent date. And
My Lord, in case of procedural law, my Lord, CRPC may not apply. DNSS may apply, my Lord. This issue requires some examination.
No. What is it?
well, it's 531B, if I'm not mistaken. my lord.
See, immediately so investigating pending, then such application
Trial.
shall be disposed of or continued, held or made, as the case may be, in accordance with the provisions of
Criminal procedure
1973 code. My brother says that Punjab Haryana High Court has passed an
Well,
order
yesterday some
saying that it is based on old code.
Malaj, if your lordships kindly have a look at 531, Malaj. A, if immediately before the date on which this Sanhita comes into force, there is any appeal, application, trial, inquiry, or investigation pending, Malaj. The expression is pending. Then such appeal, application, trial, inquiry,
So
or
according to you, this is a fresh appeal, so it has got to be filed as
it
per
has
the
to be
new
under
code.
the new code, Malaj. The important word in my humble submission would be pending, Malaj. Only if it is pending, then the old code would apply.
See, we have to interpret in such a way, the appeal is
Is a
consequence of the trial.
Continuation of the fresh.
Huh?
Continuation of the
What is
original
the trial?
Malaj. Malaj,
Otherwise, it
other
will be
matter.
defeated. Purpose will be defeated.
Malaj, only thing, Malaj, if it falls from a lordship sitting division bench.
Suppose
Malaj.
some offence,
Malaj.
the new code gives a higher punishment,
Malaj.
prescribes the new IPC,
Lordship.
prescribes a higher punishment. Can it be modified and given a higher punishment?
Malaj, no.
Well, substantive law.
So far as substantive procedural law is concerned, my lord, I'm sorry, my lord, procedural law is concerned, procedural laws are always prospective. So far as substantive offences are concerned, my lord, they cannot be applied retrospectively.
Exactly.
Logic.
Exactly.
Substantive offense would be, Malaj, under the old code, the IPC.
Full IPC.
Partly this will be followed, partly that will be followed.
Lordship.
Lordship,
Yes, sir.
kindly consider, suppose if there is a criminal appeal and a plea has been taken non-compliance of section 313 of the CRPC or 164 the CRPC, it cannot be, all this plea cannot be considered, your lordship, under the new code. It has to be considered in the light of the old CRPC.
Which is why, Malaj, the expression pending is there. The expression pending is because of those reasons.
Subject to what my brother says, the appeal is a continuation of the trial.
Lordship, yes, certainly.
It's a continuation of the trial. You have to give such a liberal interpretation.
My lord, this
I was
requires some
only-
examination. my lord.
Huh?
It would require a
This
little
issue would
examination.
require some examination.
May I pray your lordship, Malaj, fix it on a day, because this would again be an authority, Malaj, that would again throw light on matters before all courts. The lordships can have it on a day, Malaj. We could just try and assist your lordships, and some authoritative judgment can then fall from your lordships on this aspect.
Yes.
We'll assist your lordships, Malaj, in whatever we can.
Yes.
Malaj.
So we'll adjourn the matter.
Lordship,
Adjourn the matter.
Yes.
Whether the appeal filed and the new code is correct or not, we'll decide.
Lordship, yes.
Yes. We'll decide.
Right.
Anyhow, delay. The problem is the person will be languishing in the prison.
It's next week, Malaj, only on that limited issue. Our difficulties, Malaj, I am also on a similar issue before the learned single judge, Malaj. So anything that falls from
And
have an effect.
person has
After
first
302.
conviction under 302.
302.
It is 302, your lordship,
What is
yes.
the conviction?
Conviction is life, your lordship. Life. Life.
Obliged.
Obliged, your lordship.
Item number 3.
Who's on so and so date? Some date will give. Yes,
There are two aspects, my lord.
yes.
As far as the survey that was conducted, LIDAR survey, my lord, we are expecting a report by 27th, my lord.
27.
My lord. So, my lord, that will be a very scientific, a very comprehensive inquiry, my lord, and that will throw light on whether there is any possibility of expanding this Umroi runway or not, my lord. So, my lord, if the,
What is the report they
the
filed?
report has been submitted by the agency who conducted the survey, my lord.
Feasible or not feasible?
My lord, I'm not in a position to say, my lord. On 27th, if Lordship fixes the matter, I'll try to place the report before Lordship, my lord.
In the mean, yes, Mr. Amit.
Yes, my lord.
With
Your
regard to-
Lordship, so far as visit to Bhutan is concerned, my lord, if the order is modified to the extent that we just want to have a look for functioning of the airport at Paru so that we can avail the similar benefits for a smaller airport. Because probably the ward inspection has come in the previous order, my lord, and that is one of the reason for Bhutan government may not be agreeing to.
So we will make it as visit instead of inspection.
Yes, my lord.
We want
Yes,
to visit and have an idea about the airport.
Yes, my lord. Yes, my lord. Yes, my lord. So the order to that extent, my lord, is modified so that we can take
When
up the
the
matter
matter
again.
is
with the
taken up,
government of Bhutan.
when Mr. Musika submitted that LIDAR survey report is ready and it will be filed on or before 29th of this month. Mr. Amit, Senior Advocate General, submitted that the Bhutan government is hesitant to permit inspection, as according to them there cannot be any inspection by a foreign court. So this court has used the word inspection instead of visit. So and so. So we'll pose the matter tomorrow. We'll give that order and thereafter we'll give you a date.
Well,
We'll change it as visit
well,
instead of inspection. Then we'll do it. Suitably, yes, I'll give one or two sentences also. I'll dictate. You can add it tomorrow. Yes.
Great.
Item number 5.
Millards, this is the PIL concerning the Shillong Zoo, Millards.
Zoo, yes.
And status report has been filed
We
by
have
the state
submitted
today.
a status report as far as the mini zoo in Hang Nong Light Park is concerned.
Where is the new zoo, madam?
Yes, they have to.
Millards, they say
animals
that
have
most
been
of the
transferred.
animals have been transferred, except for Millards, one pregnant deer who cannot be transported
some
at this
birds,
stage.
Your
Some
Lordship,
birds,
because
Millards. They're in the
the birds-
process of transferring.
We'll call the matter. We'll also, where is it exactly? We'll go and visit her.
They have been transferred.
The High Court, Millards, could
We
always
will
go.
open the lock and enter.
It is in Reboy, just.
We must know, see, we must protect the animals and
Well, also, Millards, there's another aspect to this PIL. It concerns the implementation of the animal birth control rules, Millards, with regard to stray dogs. Now, to that extent, Millards, a response from the state would be awaited.
Your Lordship, the
except a
agency,
few animals and birds, including one deer. Deer or
a pregnant deer has not been transferred.
One
because
deer.
It is against the rules simply.
alone has not been transferred to the new place.
The rest have been transferred. And the birds are still here, Your Lordship, because
Yes, we said birds and so on. So, what's up? Post the matter on so and so date. We also can move. How far it is?
Yeah, hardly half an hour.
Half an hour.
not very fine.
We'll go and see today.
We have given the photographs also, Your Lordship. I think it is already there.
Where's the photograph?
My lords would find it at annexure 4, my lords, page 16 onwards.
15 onwards.
16, my lords, 1/6.
1/6.
We have also given the colored photographs, Your Lordship, which is clearer.
Oh, yes. Oh, it's going on. You see. Oh, veterinary hospital also there.
Yes, a morgue is also there, Your Lordship.
Good. Post on so date. You see. On the matter. First week of August.
Nice.
On post on so date. We'll also see the place. How is this?
The state may file an affidavit with regard to the ABC rules, my lords.
Dogs, Your Lordship.
What is it?
Stray dogs.
With regard to the stray dogs, my lords, there is a second part of the prayer and the
After it has
prayer.
been filed.
For
We
the
have not
dogs, we
filed
have
this.
not filed. We were under the impression that the municipal corporation would file that, but nothing has come from them.
You are also a respondent.
Yes,
You
Your
should also
Lordship. So
file.
we will do that, Your Lordship, by the next date.
The respondents are expected to file their comments on the affidavit filed by the petitioner in the next date of hearing.
Obliged.
You'll see.
Item number 6.
Obliged, Your Lordship.
This is the matter regarding the regularization of leave. Professor, on the last occasion,
You said whether 18 days leave,
18 days or 14 days, man.
18 days.
18 days.
18 days, spanning from May 2020 to June 2020. So that was lordship leave, my lord. Now the thing is this, your lordships, my lord, that was, my lord, the earned leave. That was, my lord, the earned leave. That leave was earned by her, my lord. That leave was granted to her, my lord, on payment of full salary.
No, that is right. If you treat that as a working day,
Lordship.
you should be entitled to wages apart from the leave that leave to her credit, which can be encashed at a later point of time at the time of resignation.
But no, my lord, regarding the other part, so far monetarily she is not suffering in that way. Other part, my lord, I have received the instruction, my lord. So far it is, the general decision was taken by the executive council, my lord. That has been annexed. And the general decision,
Mr. Counsel, last time we said, give a quietus to the matter by settling it. That's what we said.
lordship, my lord.
So you pay 18 days wages and give a quietus to the
My
matter.
lord, so far I am concerned, your lordship. I have received the instruction, my lord. University has slight difficulties in the sense
The
they have
Supreme
taken a
Court,
general.
Supreme Court has also posted some of the matters for mediation, Lok Adalat during the week commencing 29th to 3rd of this month, the July and August, stating that so many matters are pending in the Supreme Court. Every High Court should devote some time and ensure that the matters are settled. See, after all, no, we are now for 170, I think subject to correction, 171 days, you know?
My lord, may I
1 minute, 171 days.
Yes, my lord.
He said we pay 18 days.
Lordship.
What is going to happen?
Only thing, I have my limitation. Only problem for the university, my lord, there is a general.
See, if there is an order, it will be a precedent. If it is a settlement, it is not a precedent.
This is the only, my lord.
Yes, sir.
May I submit here, my lord? My lord, the last time I was submitting online, so there's some vital document has been left out. My lord, I have made the list of dates also. My lord, this is very much for the interest of the justice, my lord. Page 386, my lord.
We have passed a detailed order.
Yes, my lord, but this vital documents directly states, my lord, this directly states that the said period shall be counted as on being on duty for all faculty. This is from the MHRD to all the institute. My lord, page 386, my lord. My lord, I beg before you, my lord, because grave injustice will be caused, my lord. Because of my naivety, I was not able to submit online, my lord. But my lord,
See, that's not a problem, sir.
yes,
We are hearing you. We are not saying that we are not going to hear you.
my lord.
So, in order to give a quietus to the matter, which page, sir?
Page 385, my lord.
Is that you paid for 18 days wages?
385, my lord. My lord, at 3, my lord. In order to ensure the safety of the faculty members, teachers, research and non-teaching staff
of the higher education indicates the following precautions should be taken. Faculty members.
What is your leave period?
My lord, my leave period is is till 2 September 2020. And till 5th of October, I have been working. They have been assigning me online duties. That is on record. So whilst I am working.
Where is the proof that you have been?
Yes, my lord. But my proof is at page 190 to 190, my lord, of the volume number 10. 190, my lord.
190.
190, my lord.
Yes.
My lord, see, this is the notice of the dean, the School of Life. This is School of Life Sciences, where continuous assessment and paper setting for terminal semester. This was a mail that was sent to me. At page 189, my lord may see Bela Kishan online class support, 5th August. Please find attached regarding my online report for the week, July 23rd to July 29, 2020. And my lord, again at page 191, notice from the NEHU, notice from the head of department Zoology NEHU, regarding setting the question and sending to HOD Zoology by 18th August 2020. Kindly refer to the Dean School of Life Sciences NEHU, so and so mentioned, terminal semester, you are the in charge of all the terminal semester papers. Kindly submit the said question papers to HOD.
You mean where is your name?
My lord, these are the mails to me, my lord. These are the mails to me. These are an admitted fact. And this is an admitted fact can be read out from their own resolution. My lord, it can be read out in the page number 127. It is their own resolution. What page 127? 127.
Yes.
My lord, this is 126 is the resolution. It is also there in the affidavit in opposition.
Legal application as for so on. So we told
Yes.
something on the
Professor Bela Kishan.
No, till the final is on. So this is 120 or 7.
Yes.
The council resolved.
Yes. Professor Bela Kishan, page 126 may I refer to, my lord.
Where?
126, a page ahead, 126. Professor Bela Kishan has furnished a reply by letter dated 9th October 2020 that due to extraordinary situation of spread of COVID-19 pandemic, she was compelled to stay back in Kolkata and carrying out her duties online from Kolkata, and that she finished entire syllabus of the MSc and PhD work classes even semester 2020 online, and have also conducted internal assessment tests and set the question paper of internal end semester examination while working from home at Calcutta. Now, due to serious sickness of her aged mother, she is requesting to allow her to stay in Kolkata and extend her physical reporting in the department till such time the doctor advised that her mother is medically fit. Due to COVID-19 pandemic, she is...
One minute.
Yes.
So what do you say sir, to page number 126 bottom? Professor Bela Kishan. Let's furnish her reply. Letter dated 9th October 2020 that due to extraordinary situation of spread of COVID-19 pandemic, she was compelled to stay back in Kolkata. Next is very important. And carrying out her duties
Online.
from Calcutta, and she furnished entire assigned syllabus from MSc also online, and also conducted internal assessment and question papers for the internal search, so on so. So she has been discharging work.
No, my lord. Lordship, what happened here, my lords? I have pointed out the notification issued in, my lord, May 2020. May 20, before that there was complication at all. May 2020, university has taken a decision intimating, my lord, all the officials, my lord, there should be all the officials were physically required to be present, my lord. Because, my lord, the teachers are not only confined to classroom teaching or online teaching, my lord. Other than that, they are involved in administrative duties as well, your lordship. Their presence is required. So that has been circulated. She never cared to come back and join, my lord, never to send any intimation.
It is true that she has not joined.
She has not.
She is also not disputing that.
Lordship, now what happened? From the head of the department, Lordship, head of the department ultimately brought to the notice of the university, my lord, to the registrar.
So
that,
our question to you is
Lordship.
whether work was discharged by her during her stay at Calcutta
Lordship,
through online.
Lordship.
Whether she has conducted classes through online.
Online, my lord, she got a link, my lord, online classes, but the teacher is required, my lord, are also involved in administrative duties, your lordship. And university has issued a clear circular asking all the teachers, my lord, to be physically present.
Whatever
Now, what do you think about the
she has
consequences?
done part of the work she has
Now,
done.
my lord, you will see, my lord, what she did, your lordship. She never came, bothered to, my lord, join. Ultimately, my lord,
That is right.
head of the department.
So factually, we agree with
Lordship.
your contention that she has not reported for work
Lordship.
physically.
Lordship.
But the resolution of others says that she was discharging tuition work, the teaching work through online and correcting the papers. Why should she be deprived the entire wages for 171 days?
That's why, my lord, what happened? What are the consequences? When a teacher has been asked to physically join, still she abstained, my lord, that become unauthorized, my lord. That's why I have taken a
Abstain means no work at all performed by her or him.
Lordship, she has no, my lord, she was required to join physically. The admitted fact is that she never joined
That's a
physically,
misconduct.
my lord.
That's
That is not
misconduct.
misconduct, my lord. We have not gone into it. We realize that their problem.
For not joining duty may be misconduct. The fact that she has taken classes is not in dispute.
Lordship,
Then why do
Lordship will appreciate the other part, my lord. What we did, my
you
lord.
pay wages?
No, my lord,
Otherwise we'll pass
what we
orders.
did, your lordship, my lord, there is a clear case of misconduct. And considering the situation, my lord, we have not initiated any process. Instead, my lord, we took a very
In the
soft decision.
previous order, we have stated that you have not taken any action. That is there in our order.
My lord has indicated there, my lord. We have not taken any, my lord, disciplinary.
That is right.
We took a very soft stand, your lordships.
See, if you are not going to pay for 18 days, we may also increase.
My lord, may I just submit here? May I just. My lord, my learned senior friend here is misleading the court at the direct instance. My lord, I will take to page 389. My lord, it's very much clear. Page 389. They have been misleading the court from the time. Page 389, my lord.
389.
Yes, my lord.
Yes.
School, colleges, education and coaching institute will remain closed till 31st August 2020. Online distance learning shall continue to be permitted and shall be encouraged.
Where are you reading?
389, my lord.
One we read online, yes. Distance learning shall continue. Yes.
Yes, my lord now may see the interstate movement was there. Now my lord may see this resolution was updated on 29th August 2020. That is page 397.
397.
Page 397, my lord.
Yes.
My lord may see 29th August 2020, school, colleges, education institution will continue to remain closed for students and regular class activity up to 30th September. However, the following will be permitted. It's only on from 30th August it was permitted. States, union territory may permit 50% of teacher and non-teaching staff to be called to the school. And at the time of online procedure,
Teaching or non-teaching job to be called to the school at the time of online.
yes. So the state,
You may be one among the 50%.
my lord, I clear it, my lord. Now, the chiefs, the MHS, the Ministry of Home Affairs, have directed at page 404, page 404, dear Chief Secretary.
Sir, everyone faced difficulties.
Yes, my lord. But this is,
Business people, every education institution, everything.
so my lord, this is page 404, MHS, dear Chief Secretary, and it was issued to all the Chief Secretary to the
So
state.
what is it you are going to say, sir? Well, we read and pass
Lordship
orders.
will come back to three.
My lord, where is-
My notification of the university, 341, page 341,
Page
page 341,
340.
341. My lord, dated 4th May 2020. Now, my lord, that day I submitted,
minute,
your
sir.
lordship. So far,
341,
spread of COVID is
yes.
concerned, my lord, it is not uniform across the country, your lordship. And health is a state subject also, your lordship. Now, your lordship, I will just read it.
Function, 100% thing.
And the order of the
This is your decision.
lordship.
This is your notice and your decision. But when there is a government order,
And those were the guidelines, my lord. Those were the guidelines, lordship. Those were the guidelines. Lordship, take note of one fact. Spread of COVID across the country is not uniform. In some state, my lord, it was very little. Some state, it was very severe. In one state, complete lockdown. Other state, my lord, there was partial lockdown. This was the situation, my lord. So here we have taken a decision, my lord, and so far health is concerned, my lord, it is the state government subject also, your lordship. Now, state government has permitted, my lord, for physical presence of the employees, your lordship. So taking into consideration these, we have issued this notification. And in our resolution also, we made it very categorical that when there is, my lord, complete lockdown across the country, my lord, that no punitive action would be taken against the employee.
That is right.
My lord, their own notification, page 342, the teachers will keep in touch with the students through e-learning and give direction about the courses. Their own notification, column 6, my lord. Column 6, the notification is reading. The teachers will keep in touch with the students through e-learning.
You're not going to settle the matter.
Lordship, what happened here?
You're not going to settle the matter.
No, my lord, I'm not saying this. Now, my lord is pointing out this. Now, my lord, repeatedly I am saying, my lord, teachers were required also to discharge the administrative functions. While they were imparting classes through online, my lord. So far, my lord, administrative duties were concerned, they were required to be present physically, your lordship. And we have taken a decision, similar decision for all the teachers. She is not an exception.
Right. She has been allowed to work.
My lord, there is...
We may say that you pay 25% of the 25% of the wages for 171 days. We may say that.
Lordship will appreciate one thing, my lord. We have gone very soft. Considering this situation, my lord, we have not initiated any disciplinary.
Anyway, we take it to the Supreme Court. We will say that we pay 25% of the 171 days.
My lord,
My humble submission will be this, your lordship. We have gone soft. And
We
this
have
is the
gone soft,
general.
that's all.
Another thing, your lordship will see, the executive council has taken a decision. This is the epic. This is not even under challenge.
My lord.
This will have, my lord, far-reaching consequences.
You
We have taken a general decision
must
affecting all the teachers.
See, you cannot apply the uniformly in all cases. This is a situation is very bad. The COVID
No, we
situation,
understand.
that is the reason why, and having extracted work, and most of the guidelines are there, and that she has done work for a period, you pay some, that's all.
My lord.
Even if we say 10%, it comes to 17.1 days, 18 days.
my
Just
lord,
understand that.
may I submit here, my lord?
We'll give you a chance, otherwise we'll pass orders. We are planning to submit what my brother, we are planning to give 25%.
My lord,
That is that you have argued. We are going to enter a decision. Our judgment may be wrong. You take it to the Supreme Court and test it. That's all.
So what is the lordship's man? In fact, I have conveyed to them. The university has a problem because there is a general.
Who is the officer? Who is the officer concerned in this?
We have a law officer also, my lord. Through her, I send
No,
them.
who is the person who can take a decision? Ask them to appear on online. We'll convince them. We'll tell them. Though there is no need for us to do that, but ultimately we can tell them. See, both of you will be in win-win situation. If you say pay 20% of wages means 36 days. Your expenses will be more than 36 days in Supreme Court. Wages.
My lord,
My lord, the other part of it, your lordship, this is a general decision, my lord, affecting a large number of teachers.
That is why we initially, last time, subject what my brother said, you settle the matter, settlement is not a precedent.
my lord, may I just submit here, my lord, it would have full. My lord, they are saying that they are doing justice to me. Not at all. My lord may see the council.
We heard you, sir.
My lord, they had stopped my salary for 7 months. It is there on that withholding a salary from the month of December 2020 till July 7th, till they pay. 7 months they have withheld my salary.
Correct.
Yes.
After that, they have adjusted your leave to a credit and paid the wages.
My lord, may I submit?
They have not done it?
My lord, no, my lord, may I-
Initially, when he argued, we said, if the wages are paid, the leave to her credit will be carried forward. That's what we said.
Yes, my lord, may
So
I-
it will be entitled not only wages, but also encouragement of leave on the VRS or resignation or termination, whatever it is.
Yes, ma'am.
Under this
May I
context.
just submit here? My lord, this 72 days of my earned leave till 5th of October 2020, there is not a dispute that I was working online and there was only physical mode that was available to work online. So how can, when I've been on duty working, the HOD is assigning me duties every day I'm submitting, how can it?
Which page?
My lord, page 128 is my 72-day earned leaves.
72 days.
Yes, at page 128, my lord.
Page 128.
Yes, my lord. Till excluding the summer break. And my lord, at page 134, my lord.
120.
128, my lord. Till 2nd September, they have taken it as a earned leave, my lord.
1 minute. In person, so on so, you have applied for absence, so on so, according 72 is earned leave. This is 128 is earned leave 18 days. 55 days.
from 11 September to 2nd September 2020.
That is right. This is the, so how many days,
I've been working. I was working till 5th October. My lord, my page, see at page 134. 134. Then to come at page 135. It's a serial of my work. What I did. My lord may see.
1 minute, sir. 1 minute, sir.
Yes, my lord. I apologize, my lord.
134. These are the work.
Yes. 135, my lord may see.
135. Yes.
1st July 2020. In the internal page number 51.
Up to
135, my lord. At 1st July 2020.
Yes.
Yes. A report of online academic activities sent to HOD Zoology through email. Email to the HOD New for being out of station.
Up to which date?
1st July, my lord.
1st July to?
1st of July till, my lord, it is till 5th of October. 7th of October. At page 138. Report of online activities sent to HOD Zoology through email. It is only on 5th of October that they inform me that you have to report to the university on 12th of October. So by that time I was already working, my lord.
Yes, sir.
Lord, you will see the HOD's letter here, my lord. I'll take my lord to the HOD's.
Okay. You pay 50 days wages. Otherwise, we'll pass orders. What is it? Sir, you pay 50 days wages. Otherwise, we'll pass 2 months wages. We'll say that you pay 2 months wages. 60 days wages. 1/3. How much it will come for 60 days?
My lord, I just pray before my lord that my earned leave should be adjusted with my half pay.
That is right, sir.
Yes, my lord. That was it.
How much you will get?
I will get, my lord, they have deducted around 3,50,000.
How much you will get, sir? We don't want the calculation.
My lord, I also, I'm not aware of the
You should
calculation.
have,
My lord, I just,
see, on that day itself we said 18 days. What is 18 days wages?
my lord, if my lord, it will be something around 2 lakh something, my lord.
For 18 days.
No, for 2 months. For 2 months it will be 54. Because my lord, it's a simple calculation. If 99 days they have subtracted.
Sir, we are not on that.
Yes, my lord.
What's your monthly salary? Can you not say that?
My lord, just 1 minute. I'll just,
These are all not out of portion.
my lord, I just 1 minute, my lord.
What is this, sir? Ask the officials to appear online. They need not appear physically. We'll tell them. The court is inclined to grant some relief.
For a second, your lordship, if I can just stick to one letter, my lord. Hey, HOD, my lord, my lord,
We'll
HOD.
hear you further. We'll hear you further. Let them appear. See, we
Now,
want
what lordship is indicating, my lord? Lordship has last occasion indicated
18. Now it is increased to 60.
60 days.
60.
I can convey to them, my lord. But our difficulties, my lord, I have placed.
They will
What is
come.
our difficulties?
They will immediately they'll say that they pay 30 days or 18 days. They will agree for 18 days now.
May I submit
Now
him?
when we have increased to 60 days, they will agree for 18 days.
80 days.
Initially we said 180.
My-
Now we have increased to 60. They will say we'll pay 18 days. Definitely they will do.
My lord, may I submit him, my lord?
We'll ask them to appear. We'll persuade. See, the next hearing with them appear. We'll tell them, are you going to pay this amount or not?
May your lordship, my lord, so far this, what your lordship wants, they be appeared through BC. My lord, let me find out, my lord.
Who's missing?
No, what your lordship is saying, they can appear online. So, my lord, I'll just find out the concerned official, my lord, who is dealing with the matter, and whether.
The online, what is going to come? We are not asking physically. We are asking them to come online.
That is what I am saying, your lordship. Only your lordship, my lord, if I can just convey this message, my lord, to the
We'll pass an order.
lordship.
We'll pass an order after hearing the parties.
My lord wanted to know the amount. My lord.
What's the amount?
Yeah, 1,75,000 per month.
1,75,000.
My lord.
After hearing the arguments of both the parties, the appellant was able to show that he was discharging the duties by conducting classes online apart from other work. It has been represented by the respondent that there is an order pursuant to which all teachers have reported for work and this person, the appellant has not reported for work. The leave to his credit has been adjusted. A female. Leave to her credit has been adjusted and the entire settlement has been made. Also, the appellant has requested that her leave may be adjusted and be relieved from services. Full stop. Only after getting the relief pursuant to the resignation, the present writ petition has been filed, which was dismissed by the learned single judge and now pending before the division bench. Full stop. The petition drew the attention of this court to page number so and so to show that she was conducting online courses. Full stop. Initially, when the matter was heard last, we, in order to give a quietus to the litigation, suggested that wages for 18 days may be paid. Full stop. After hearing the arguments of both the parties, we are of the view that the wages up to 60 days can be paid. During the COVID time, everybody suffered loss, and by paying the entire amount, even if the petition would be entitled to, will put the institution to serious loss, which we are not inclined to. However, this observation is based on the submission that is going to be made by both the parties the next date of hearing. So, in order to give a quietus to the matter, we suggested to the respondent that the concerned official may appear through online so that we can convince them to settle the matter, as both parties will end up in win-win situation. Post the matter on so and so to enable the parties to appear through online. Enable the respondent, concerned official, to appear online. This you produce to them, then we'll see.
Let's send a copy.
We'll get the order copy by tomorrow.
My lord, a date may be fixed, my lord.
We'll fix a date, sir. 2 weeks after we'll fix.
2 weeks.
Yes.
Item number 7.
Much obliged, madam.